I would suggest that they need not to be in the presence of a firearm.
Reasonable to conclude that gun confiscations facilitated by laws requiring the registration and licensing of firearms.
Do arm braces make firearms more powerful?
They do not. They do not.
They are there to protect themselves against the people that are coming to those same public parks that have bad intentions.
Supreme Court denies review. So the big buzz around town, well, the legal town, is that the Supreme Court gave a hard pass to diving into the Trosivia versus Suffolk County case. You know, the one where they were supposed to weigh in on this whole hot potato of warrantless firearm seizures. Yep, that's the one. So what's the deal with the Supreme Court saying, nah, we'll sit this one out? It's a pretty big deal, honestly. See, when the highest court in the land decides not to peek into something, it's like leaving a puzzle half solved. This denial to review leaves this whole issue of confiscating firearms without a warrant sort of hanging in the air. Why is it important, you ask? Well, here's the scoop. Legal precedent. When the Supreme Court declines to step in, it's like saying, hey, the lower court's decision? That's cool with us. But here's the kicker. It might send a kind of loosey-goosey precedent. Remember, this Trosivia case was all about the Second Circuit doing its own thing, not towing the line with a prior unanimous Supreme Court decision that said, hold up, you can't just snatch firearms without a warrant. By not diving into the Trosivia pool, the Supreme Court missed a chance to drop some serious clarity truths. See, when they take on cases, especially ones with big constitutional implications like this one, it's like they're handing out a legal roadmap. But by passing, it's like leaving us without GPS on a road trip.
Reasonable to conclude that gun confiscations facilitated by laws requiring the registration and licensing of firearms.
I would suggest that they need not to be in the presence of a firearm.
You have a particular bone to pick as it relates to where you cannot carry a gun.
So what could this mean for the future? Well, it's kind of like a wild card now. Other courts might look at this and think, hey, if the big guns up top aren't getting involved, maybe we can handle things our way too. It creates this atmosphere of uncertainty about how the Fourth Amendment protections regarding warrantless searches and seizures, especially when it comes to firearms in your own home, should really be interpreted and enforced. All in all, this denial by the Supreme Court, while it might seem like they're just passing on one case, could have ripples, big ones, on how similar situations are handled down the legal pipeline. It's like they hit pause on a movie right at the cliffhanger, and now we're all left wondering what happens next. Trosivia versus Suffolk County. All right, let's dive into the drama that is Trosivia versus Suffolk County. A clash of legal titans, the Second Circuit and the Supreme Court duking it out over the rightful handling of firearm confiscation without a warrant. So what's the beef between these courts? Well, it all starts with a situation where the Second Circuit, that's a group of judges in a specific federal court, decided to go a bit rogue. They didn't exactly see eye to eye with previous Supreme Court decisions, especially when it came to grabbing firearms without waving around a warrant. Now, what's the fuss about confiscating guns without that magical slip of paper called a warrant? It's like this. Imagine someone swoops into your home, no paperwork, no official nod, and starts picking up your stuff, your firearms in this case. The Fourth Amendment, the one about unreasonable searches and seizures, has something to say about this. It usually requires a warrant signed by a judge saying, yep, go ahead and take a look. But here's the kicker. In Trosivia's case, the Second Circuit seemed to have a different playbook. They were all about this special needs exception. It's like that one friend who always finds a loophole in a game. They say, oh, we don't need a warrant here because we've got this exception card. They argued that in certain situations, like maybe when there's a risk to someone's safety, they can sidestep the warrant rule. However, this whole shebang clashed with what the Supreme Court had previously laid down in their decisions. The Supremes, in a different case called Caniglia versus Strom, were pretty clear. You can't just stroll into someone's home and snatch their firearms without a warrant. They put their foot down and said, nope, that's not cool. So here we are with Trosivia caught in this legal tug-of-war. On one side, you've got the Second Circuit waving the special needs exception flag, and on the other, you've got the Supreme Court saying, hey, we've already decided on this. This clash between these courts isn't just about legal jargon. It's about your rights, your home, and the rules that govern what can and can't be done without proper authorization. The big question mark hangs over how far exceptions like special needs can stretch the boundaries of warrantless firearm seizures. And that, my friend, is what sets the stage for this legal showdown. Origin, allegations, and police involvement. All right, let's kick off with the spark that lit the fuse in the Trusivia versus Suffolk County case, the initial complaint that set the wheels in motion. It all started with a teenage granddaughter ringing up social services, sounding the alarm about her grandpa. She made some serious allegations, claiming her grandfather was acting all kinds of irrational. Now, this call had some serious consequences because social services didn't waste time. They got on the horn with the Suffolk County Police Department pronto. So what did the cops do when they got wind of this alleged irrational behavior? They did what they do best. They showed up at Mr. Trusivia's doorstep. But here's the twist. When they actually laid eyes on the situation, they were like, huh? What's the big deal? The police officers did their whole assessment gig, chatting with Mr. Trusivia and probably scratching their heads because they found zilch. No sign of any crimes, no smoke where there's fire, nothing. They pretty much agreed that the granddaughter's complaints were as solid as a sieve. But just when it seemed like everything was about to fizzle out, things took a bizarre turn. In the middle of this whole chat between Mr. Trusivia and the officers, a little mishap happened. One of those magnetic drapes took a tumble. Now, this seemingly innocent incident triggered some serious drama.
We allow criminals to have firearms, then we're at risk.
Joseph Story, in his commentaries on the Constitution in 1833, quote, "The right of the citizens to keep and bear arms."
An officer accidentally knocks something over. Mr. Trusivia tries to pick it up, and boom, suddenly there's yelling, and the officer's threatening to tase Mr. Trusivia. Can you believe it? From a simple chat to a threat of a taser? Anyway, Mr. Trusivia reportedly tries to reason with the officer, mentioning he's got a heart condition and a zap could be seriously bad news. Next thing you know, he's in cuffs and off to a mental health facility for a psychiatric evaluation. So this whole saga kicked off with a granddaughter's call about her grandpa's behavior, the cops showing up, finding nothing awry initially, and then out of the blue, a taser threat leads to Mr. Trusivia being whisked away for an evaluation. It's like the calm before the storm. Everything seems fine, and then chaos hits out of nowhere. Arrest and mental health facility. As if things couldn't get more tangled in this Trusivia saga, here's where it takes a wild turn. Right after the cops arrived, and chaos ensued. Mr. Trusivia, probably thinking it's just another routine chat with the police, suddenly finds himself in a topsy-turvy situation. One minute, they're all discussing a fallen drape, and the next, an officer's yelling about tasers like they're going out of style. Amidst the chaos, Mr. Trusivia, rightfully concerned about his health, tries to reason with the officer, letting them know about his heart condition. But instead of easing things down, the situation amps up. Next thing he knows, he's in handcuffs, being taken to a mental health facility. Can you imagine the disbelief? From a minor incident to cuffs and a psychiatric evaluation, it's like a roller coaster ride without the safety harness. Now, the details of that interaction between Mr. Trusivia and law enforcement, well, they're a bit hazy. What we do know is that it went from 0 to 100 real quick. The officers, probably thinking they were handling a routine call, found themselves in a situation where tensions escalated faster than you can say misunderstanding. Unfortunately, that incident spiraled out of control faster than anyone expected. Before he knew it, Mr. Trusivia was caught up in this whirlwind of events, arrested, and whisked away to a mental health facility. It's like someone hit the fast-forward button on a drama, skipping all the calm scenes and jumping straight into chaos. That interaction, that sudden turn of events, became the spark that set the entire legal battle in motion, and it's wild how what might have seemed like a minor incident ended up being a catalyst for this entire case. Special needs exception. The special needs exception, the legal twist that raised eyebrows and caused a stir in the Trusivia versus Suffolk County case. Strap in for a ride through the legal maze. This special needs exception is like the wild card in the legal deck. It's the loophole, the get-out-of-jail-free card. Well, sort of. It's this idea that in certain situations where there's an urgent need or a risk to safety, the usual rules, like needing a warrant, can take a back seat. In Trosivia's case, the Second Circuit Court seemed quite smitten with this special needs exception. They basically said, hey, because there might have been some concerns about safety, we can sidestep the whole warrant thing. It's like saying we had to act fast for someone's safety, so rules be darned. Now here's where it gets tricky. The Second Circuit had this legal toy, the special needs exception, and they decided to play with it. They used it as their ace card to justify the seizure of Mr. Trosivia's firearms without that golden ticket called a warrant. But the real kicker here is the application of this exception. It's like when you try to fit a square peg into a round hole.
Do arm braces make firearms more powerful?
They do not. They do not.
They are there to protect themselves against the people that are coming to those same public parks that have bad intentions.
We have a Second Amendment because we understand in this country that there are some things, inalienable rights.
The Second Circuit stretched this exception, applying it in a way that raised some eyebrows. They seemed to use it liberally, perhaps more than what was intended, saying, well, because safety concerns were raised, we're going to sweep in and take those firearms without bothering about a warrant. It's a bit like bending the rules to fit a situation, but in doing so, it raised questions. Did they stretch this exception too far? Was it really a situation where the exception should have been applied, or was it more of a legal contortion act? That special needs exception in this case became the go-to justification for seizing firearms without a warrant. But in doing so, it became a hot topic of debate. Did the Second Circuit stretch it beyond its intended use? That's the legal tango they waltzed into, and it's a big reason why this case raised so many eyebrows. Caniglia versus Strom. Let's talk about Caniglia versus Strom, the legal ground that got some serious attention in the Trosivia versus Suffolk County showdown. In Caniglia's case, the Supreme Court took center stage to settle a big debate: warrantless home entry and firearm seizure. Mr. Caniglia had a little tiff with his wife, and the cops showed up. Things calmed down, but the officers, they were like, hey, we're taking those firearms, and we're not asking for a warrant. Now, Mr. Caniglia wasn't having it. He argued that this was a breach of the Fourth Amendment, that whole unreasonable searches and seizures bit. The case was a showdown between the cops saying, special circumstances, we can do this without a warrant, and Mr. Caniglia saying, nope, not cool. And guess what? The Supreme Court stepped in, dropped the gavel, and said no can do. In a unanimous decision, they laid it out. Warrantless entry into someone's home and snatching firearms? Nope, unconstitutional. They basically said, your home is your castle, and we're not letting anyone storm it without a proper invite. Now, let's play the compare and contrast game. Caniglia and Trosivia, they're like distant cousins with similar arguments but different scenarios. In Caniglia's corner, it was all about the cops barging in and taking guns without a warrant. The Supreme Court said, nah, that's a no-go. On the other side, Trosivia's tale was about the Second Circuit waving the special needs exception flag to justify firearm seizure sans warrant. They said, it's a safety concern, so it's all good. The similarity? Both cases were grappling with the same Fourth Amendment concerns about warrantless seizures of firearms from homes. But the difference? How they approached it. Caniglia got a clear-cut unconstitutional, while Trosivia got tangled in this dance of exceptions and interpretations. It's like the Supreme Court laid down the law in Caniglia, setting a standard. But the Trosivia case? Well, that's where things got a bit blurry. The Second Circuit seemed to dance around the established precedent, leading to this whole showdown about how far exceptions like special needs can stretch the rules. In a nutshell, Caniglia set the tone, drawing a line in the sand, while Trosivia stirred up this storm of debate about where that line really lies when it comes to warrantless firearm seizures. Second Circuit ruling and departure from precedent. Let's talk about the Second Circuit's leap of faith, or maybe we should say leap away from the established Supreme Court precedent in the Trosivia versus Suffolk County showdown. So imagine this. The Supreme Court laid down the law in Caniglia versus Strom, making it crystal clear that warrantless entry into someone's home to seize firearms is a big ol' no-no. It was like they stamped unconstitutional in bold letters. But here's where the Second Circuit took a different route on the legal highway. They seemed to say, well, we're not exactly following that roadmap, and decided to deviate from that established precedent. It's like they pulled a U-turn when everyone else was going straight. Their reasoning? They had this legal ace up their sleeve. the special needs exception. They argued, hey, because there might have been some concerns about safety or well-being, we're going to bend the rules a bit. But here's the rub. This departure from prior unanimous decisions, especially the one set by the Supreme Court in Coniglia, raised more than a few eyebrows. It's like the Second Circuit pulled out a different playbook and said, we're doing things our way. Their reasoning seemed to tango around the established precedent. Instead of towing the line with the Supreme Court's clear stance on warrantless seizures of firearms, they did this legal twist and dance with the special needs exception.
We crushed it, baby! We crushed it!
Roughly 40 million firearms with stabilizing braces in circulation to obtain a special registration.
And yet at Uvalde and in so many other school shootings, we were not willing to protect our children.
It's important that our Constitution does have a Second Amendment.
I think that all the amendments are important. It's very hard to start comparing.
From engaging in defense from imminent harm.
Large capacity magazines increase.
If elect, I intend to bring all of Suffolk together.
It's a bit like a game of legal gymnastics. The Second Circuit took this established rule and tried to bend it, stretch it, and make it fit a situation where maybe it wasn't meant to fit. They departed from that clear-cut decision and ventured into murkier waters, interpreting the law in a way that raised questions about how far exceptions like special needs should stretch. In a nutshell, their departure from prior unanimous decisions, especially one as clear as the Supreme Court stance in Coniglia, was like veering off course. It's what caused all this legal hullabaloo and made this Tricivia case a hot topic of debate about how closely lower courts should stick to established legal precedent. Petitioners' arguments and government's response. In the Tricivia versus Suffolk County saga, let's unpack the arguments thrown into the ring by the petitioner and the government's counterpunches. The petitioner, seeking a review from the Supreme Court, came out swinging. Their main punch? They argued that the Second Circuit Court did a legal shuffle, ignoring the clear precedent set by the Supreme Court in Coniglia versus Strom. Their stance was crystal clear. The Second Circuit didn't just toe the line with the Supreme Court's ruling against warrantless firearm seizures. They argued, hey, this is like deja vu from Coniglia and it's not cool. Their knockout point? They claimed that the Second Circuit's tap dance around this precedent was, in their words, the plainest of plain errors. They wanted the Supreme Court to step in and set the record straight, waving the red flag of a serious departure from established law. But here comes the government putting up its defenses. Their response? They jabbed back, saying, hold on a sec, there's a technical glitch here. They argued that the petitioner didn't exactly present their case in the right legal format. It's like they were saying, you didn't dot your I's and cross your T's properly. Their main counterpunch? They threw shade at the petitioner, claiming that since they dropped certain claims related to improper entry into the home, the Coniglia precedent didn't exactly apply here. It's like they were playing a game of legal chess, moving pieces and arguing technicalities. The government also took a swing at the petitioner's claims, saying that because the petitioner didn't explicitly claim improper entry in a different light, the Coniglia case shouldn't be the golden ticket for them. In essence, while the petitioner was shouting, hey, look at this big departure from established law, the government was firing back with, not so fast, your legal paperwork's got issues, and the Coniglia precedent might not be your silver bullet here. It was a legal tug-of-war where the petitioner argued for a review based on the Second Circuit's departure from established precedent, and the government countered, citing technicalities and questioning the application of that precedent to the specifics of the case. Denial of certiorari. The Tricivia versus Suffolk County saga reached a pivotal moment when the Supreme Court made a decision that, in legal terms, might seem like hitting the pause button. Brace yourself for the inside scoop on the Supreme Court's denial of certiorari and the seismic implications it carries. So what's the deal with this denial of certiorari? Essentially, it's the Supreme Court saying, we're not going to step into this boxing ring. It's not a verdict on the case's merits. It's more like the court choosing not to pick up this legal hot potato. When they deny certiorari, they're not diving into the nitty-gritty of the case. Instead, they're leaving the lower court's decision intact. Now, why is this denial such a big deal? Picture the Supreme Court as a beacon of legal clarity, the voice that sets the record straight. When they decide not to weigh in, it's like leaving a riddle unsolved. In the Tricivia case, it means the Second Circuit's decision the one that departed from established precedent, stays put. It's like the Supreme Court saying, we'll let that decision stand for now. But here's where it gets spicy, the implications. This denial of certiorari casts a shadow over the legal landscape, especially when it comes to firearm seizures and your Fourth Amendment rights.
Simple. I will read, if I can find underneath all these amendments.
And their recent actions against firearms manufacturers, federal firearms licenses, or FFLs.
Or policies as before us today to make it harder for law-abiding citizens to obtain firearms.
Year-old adults, guns that are in common use. It bans for everyone.
Think of the Fourth Amendment as the guardian of your privacy and sanctuary, your home. It's the one saying, you've got rights, and we're not letting anyone barge in without a proper nod from a judge. The denial of certiorari here? Well, it's like dimming that guardian's torch. See, by not stepping in, the Supreme Court isn't offering that much-needed clarity. They're leaving the door ajar for interpretation. Lower courts might look at this and think, hey, if the bigwigs up top aren't getting involved, maybe we can handle things our way too. It's like giving a green light to uncertainty in how the Fourth Amendment should be interpreted and applied, especially in cases of firearm seizures without a warrant. This denial could set a shaky precedent, one where lower courts feel they have more leeway to deviate from established norms. It's like leaving the rulebook half-written, giving rise to doubts about what's fair game when it comes to seizing firearms without a warrant. And that's a big deal when we're talking about something as fundamental as your rights in your own home. The denial of certiorari in the Tricivia case, while it might seem like just another legal step, sends ripples through the legal pond. It's like leaving a question mark hanging over the extent of Fourth Amendment protections and the boundaries of warrantless firearm seizures. In a nutshell, this denial might not be a knockout punch, but it sure adds a cloud of uncertainty to the legal skyline. It's a missed chance for the Supreme Court to offer clarity and leaves a lot of folks scratching their heads about where the line really stands when it comes to safeguarding your home and your rights. Implications and uncertainties for Fourth Amendment rights. The denial of review in the Tricivia versus Suffolk County case isn't just a legal footnote, it's a seismic shift in the landscape of Fourth Amendment rights, and the repercussions could echo far and wide. Let's start with the broader implications. By slamming the brakes on reviewing this case, the Supreme Court essentially left the door ajar for uncertainties to creep into Fourth Amendment protections. It's like they hit the snooze button on settling a crucial debate about warrantless searches and seizures, and that sends shockwaves. Now imagine this denial as a cloud of ambiguity hovering over the sanctity of your home. The Fourth Amendment, your fortress against unreasonable searches and seizures, has always been the guardian at your doorstep, demanding that a warrant be the ticket for entry. But with this denial, that guardian seems to have lowered its sword a bit. The uncertainties that unfurl from this decision? Oh boy, they're a legal minefield. Lower courts might glance at this denial and think, maybe we've got a bit more wiggle room in interpreting the Fourth Amendment. It's like leaving the door open for creative interpretations, and that's not exactly a comforting thought when it comes to safeguarding your privacy and rights within your own four walls.
Striking a clause in the preamble is per se germane, neither adds nor subtracts, and police.
But now you secretly let out what the real purpose of it is. It's to claim that Democrats.
Bills for National Police Appreciation Week, we took up the actual bill.
And no one contends otherwise. But what are the limits? Wouldn't it be nice to hear?
It requires agencies to submit a rule to Congress before the rule can take effect. After submission of a rule by the agency,
the next time a situation arises where firearms are involved, the lines might blur. Courts might wade into murky waters, thinking they have more freedom to bend the rules. It's like turning what should be clear-cut protections into a gray area. The consequences? It's like playing a game of legal Jenga, where the blocks of protections might start to wobble. You've got this foundational right, but when the Supreme Court doesn't set a clear precedent, it's like yanking one of those blocks out. The entire structure becomes a bit shaky, and that's concerning when it's about something as fundamental as your rights against warrantless searches and seizures. It's not just about this one case, it's about the precedent this denial sets. It's about the domino effect on future cases where the absence of a clear directive from the Supreme Court might embolden lower courts to test the boundaries. In essence, this denial of review doesn't just affect Tracivia, it's a ripple effect that could cast doubts on the very bedrock of Fourth Amendment protections. It's a missed opportunity for the Supreme Court to draw a clear line and instead leaves us with a murkier picture of where the boundaries lie. And that's a cause for concern when it's your rights on the line. That's all for this video, folks. See you next time.